Hello, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today, we have a great webinar on what happens after my lien is filed. How do I get paid? By construction lien law expert Russell O'Rourke. Without further ado, I would like to introduce Russell O'Rourke.
Good morning, Diana. Thank you. So I'm sure everybody has been here before, but in case you haven't, let's move forward and get to page 2 here, which is the using the chat box. If you have any questions, please put them in the chat box and Diana will be addressing them. She will be watching that and make sure that I have any questions able to answer for you. So with that, let's get started on the program. I'm sure what happens here to begin with is you've all done your due diligence, you did your preliminary notices through SunRay, and you're still not paid. Then what happens? Well, you're going to file a lien. We're going to talk about how all this is going to work. But you get your lien filed, and then what? It's just a lien. A mechanic's lien is a tool, like any other tool you use to do your work. This one is just a tool that you use to get paid. So there it is, it's there. Now what do you do first? The very first thing that I recommend you do is wait. And the wait may not take that long. The wait may take, an hour by the time they find out the lien is on, or it may take a day or so, which is the usual type of time where if I have filed the lien, I get the call from the other attorney to say, well, you've got a problem here. I don't think you did a notice of furnishing, and show me your green card and all that. So now we have some response, and that's what we want. We want one of two things to happen. The very first thing that is more likely to happen is the response that's trying to defend. We'll get there in a minute. The other thing is, oh my God, this is the worst thing that's ever happened. And we know, where do we send the check? That happens sometimes, not every time. So we're waiting for the reaction, and then their reaction will be complete silence. Sometimes you just don't hear a thing. If it's a smaller project, particularly one where they're not worried about financing, even if it's a big project, if financing isn't an issue, sometimes you don't hear a word. I know I file a lot of mechanics liens. I've been doing mechanics liens since 1987. And I can think of one that's just, I filed a lien, probably last October about this time. And the first thing that happened was absolutely nothing. Nobody said anything, not to me, not to my client. It wasn't until mid-August when they were trying to do the permanent financing and the lender saying, well, you got these liens here, so we got to get paid. You have to pay them off. You have to release the liens. You have to do whatever. So the silence was remedied by the lender stepping up. The next thing is aggression. Started to talk about this before. The first call, usually you don't hear. If you hear, they call you, probably from the client. It's probably from your customer, which may be a subcontractor, maybe a contractor, maybe the owner. Sometimes the client, your customer, calls you. Usually it's their lawyer calling me. Their lawyer really shouldn't be calling you because they know you're represented by me because my name is on the bottom of your lien. Excuse me. So they need to, if the lawyer's going to call, needs to be to me. And they always say the same things. The contractor owes you nothing. There's all these back charges. You didn't get any, you have change orders you're trying to claim. Well, we never signed any change orders. this lien is a slander in the title. We're going to sue you. You're going to have to pay us for 1,000 different things. And the last thing is the one I mentioned to begin with, which is you didn't do your paperwork right. You didn't get the notice of furnishing done correctly. You filed your lien too late. There's a myriad of different things that you hear in response in an effort to try and make us go away. Well, we're not going away. So if you start to get that aggression, you get it. Yeah, I'm going to say call your attorney. And just so you're all on the right page, it's best to ground yourself. If you're going to do the negotiations, it's best to ground yourself and know what the rules are, because you're going to hear the things that I just said. No change orders signed. You didn't do your paperwork right, that stuff. So the next thing, rather than just that aggression, they can start to defend. And now I've got 2 exclamation points beside call your attorney. The one is a notice to commence suit. It's a great defense. Well, it's a great tool to try to defend, because you have a very short period of time. You have 60 days to file a lawsuit if you get a notice of commence suit. If you don't commence your suit within 60 days, you don't lose your contract rights, but your lien rights go away. And what happens frequently when people send a notice to commence suit out, they get it on their desk, they're busy, they put it there, they put something else on it, they say, I have to call the lawyer and find out what this is all about, get it going, whatever we're going to do. And that's fine, except for the fact that you just put a piece of paper on top of it, and you usually find it about 61 days later, which is, a day short and $1 gone away, because you have no ability. If they did their notice to commence suit correctly, you're done. If you get a notice to commence suit and you call your lawyer on the 59th day, they can't get it done for you in time. There's too much to do. In some counties, because you go to the Court of Common Pleas in the counties, some courts require that you file a preliminary judicial statement with your lawsuit. And if you don't have it, it's untimely. Preliminary judicial statement comes from a title company. A title company takes some time to do it. It may be, you might be able to get it to turn around in a couple of days, but they have to research title. It's a title policy saying where you are. It identifies every lien claimant, every lender, anybody who has any claim to the property is listed on that. That's a requirement for the lawsuit. So you want to give your lawyer at least 2 weeks, and there's no reason to do it that far in it or that close to the time period. The best thing to do is pick up the phone, email a copy of the notice to commence suit to your lawyer, along with the method of delivery. Usually it comes by certified mail, registered mail from the sheriff. Got to be served by the sheriff. Send that to your lawyer so they know how to react to that. The other thing they can do is they can try to bond off your lien. And we'll talk about that a little more in detail. The next thing is they call and they want to negotiate. And do you call your attorney? Maybe, probably. But if they call and say, this is all a big mistake, I'm sorry, we can get you a check. We've got this deal. They're going to close the lending on next Tuesday, so we need to have it released by then. No, you're not doing that. You don't want to do the release yourself. You want the release done correctly, so you're going to have your lawyer do that. And if they're going to pay you out of a closing, like the refinance, we're going to send the release to the title company, and the title company is going to hold it and pay you before they file the release. I frequently hear, we'll talk about this a little more in a moment, release that lien, we'll get paid and we'll pay you immediately. Yeah, no, that isn't going to happen. You filed the lien because you weren't being paid. So if you release the lien now, almost assuredly, you cannot put it back on. It's not like you can say, yeah, okay, well, I took it off by mistake. No, if you release it, you're finished. You can't go back. So we're not going to release it that way. We can release it any number of ways, but that's not one of them. And the last thing is payment. That's fine. If you notice, every one of these is call your attorney, and I know you're thinking, well, he's an attorney, just like the solution to every problem for a carpenter is a hammer. The solution to every lien problem is call your attorney, and the answer is, well, yeah, because there's just so many things to do and do correctly to get it done right and get paid. Your goal is to get paid. So they send you a check when you're going to release the lien. Well, unless you really trust them, you're going to release the lien after your check clears. If the check comes from a title company, pretty much I'm going to trust the title company. If it's a certified check, if it's a wire transfer, fine. We'll release it today. But otherwise, it's got to clear. And they're not going to like that. So we make arrangements on how to do it. Who should negotiate for you? One of the problems with negotiating is if you're negotiating for yourself, you're the final answer. You can't back out of something. If you commit to something, you're committed. If I say it, I'm not going to say, oh yeah, my client will do that. When I hear a proposal from them, which may be a counter proposal to something I've already given them, is I think that's good, I think that's bad, whatever. I will talk to my client and see. You don't have time to think. If they say, we're going to pay you 92 cents on the dollar, and you say, well, should I take that or not? That's a discussion you should have with your lawyer to figure out, unless the contract is just so fat and you'd rather get it right now, this moment. Make a plan so it works right. Your lawyer always has the ability, plausible deniability when they're negotiating for you. Don't ever be the one negotiating when you have the last word. I represent all kinds of, mostly subcontractors and suppliers. On a lot of these businesses, they're small businesses, husband and wife type of thing. And what I always tell people, if they want to negotiate, whichever one of them is doing the negotiation, the other one has the final say. I have to, yeah, that sounds reasonable. I'll talk to my wife about that and see if we can do it. Well, no, I'm the man. I should have the final say. Even if that's true, you don't tell them that because you want the ability to continue to negotiate. Assume that everything you say is being recorded. So consider recording it yourself. So you have the same ammunition going back and forth when they say, well, we've got you here because you said this. And you say, well, let me go back and listen to the recording. If you're in Ohio and you're talking to another person in Ohio, you can record without getting their permission. If you're talking to somebody in another state, that's a different story. You don't necessarily know. You have to comply with the rules in both states. So if you're talking to somebody in Ohio, go ahead and record just because you agreed to it. Only one party has to agree. And, well, say yes. Even if you're the best, if there's a lawyer, hey, whoever's talking to you, the lawyer, the surety who is, they're going to have to pay on the bond, whatever it is, a debt collector's calling you. Use your construction lawyer to do this. It's not going to cost you that much money. It's going to save you time. It's going to save you the almost the heartache of having to fight with these people when they're trying to take your money out of your pocket. And they're always trying to take the money out of your pocket. You wouldn't have had to file a lien if they weren't. How to use the lawyer effectively? You know, if you're going down the line and you're either negotiating or you're getting into a lawsuit, your lawyer has to know everything. You know, she needs a copy of the contract, a copy of every proposed change orders, their response, every notice of default. If you were delayed, all the notices that you sent out, every notice, everything, whether you think it's going to help your case or not, you have to give it to your lawyer. You know, I hear all the time, I didn't think that was important. What does your lawyer need to know? Everything, the good, the bad, the ugly, particularly the ugly. Because if there's something that's really dreadful there, you're thinking, I'm really embarrassed I did that, or I know that's going to hurt me if we have to admit that in court. You don't have to admit anything, because pretty assuredly, they already know. You know, if you are a subcontractor or supplier, you think your job is to build a building. Yeah, pretty much. It's 50% to build a building and 50% to keep good paperwork. And if you don't have good paperwork, no matter if you're the contractor, subcontractor, supplier, you're going to be hung out to dry. So whatever it has, you should be papering everything. And whatever you've done, make sure the lawyer knows. And I'm repeating myself, but that's important. I mean, one of the other things that, you know, you've given lien waivers along the way on interim payments. Be sure you use a good lien waiver, because you may have waived all your lien rights. Maybe you only have retainage left, yet you have given a final waiver of lien. Some liens are called partial waivers at the top, but you read the language and they're not partial waivers. Make sure you understand how you use your documents so you don't end up in a way that keeps it from you ever being paid. People often think that I'm right, so I'm going to win. I read a book a long time ago. It was Dr. Phil. And Dr. Phil at that point was a consultant with Oprah. And Oprah was being sued by the Cattlemen's Association because she said something derogatory about beef. Cattlemen's Association in Texas. Well, she knew she was right. And he had to talk her down off the ledge, at least it says so in the book, because I know I'm right. I don't have to worry here. And his answer was, you might be right, but the jury might not think that's true. We have to be able to prove it. So A, you have to prove it, and B, you have to prove it at a reasonable cost based upon how much you're owed. You know, if it's going to cost you $1,000 to prove something because you need an expert and you're arguing over $1,500, I think it's time to negotiate, because let's not spend the $1,000 on the expert to prove you should have gotten 15. You're not going to get that $1,000 back. So you have to do a good business judgment. They say, you know, the only people who win are the lawyers when you go to court. Yeah, pretty much right. Court is so expensive. Dispute resolution is so expensive, particularly if it's an arbitration or litigation. It costs so much money. And if you've not done it before, it's a horrible experience. It takes away the time you should be spending on doing your work, making money, rather than sitting in court trying to convince the judge or a group of jurors how right you are. Cases don't frequently go to trial. About 2% of cases actually make it to trial. They settle along the way. Be ahead of the curve. Be sure you have a lawyer that thinks about doing this the right way at the least cost to you. There's always surprises that come up, and the worst ones are when your lawyer finds about it at trial. This is going back to, yeah, tell them everything. Give them every piece of paper, every email, every text that you have. How do you get it? How do you get a case resolved? Through negotiation, where your lawyer and their lawyer are working on it, and you're kind of negotiating through them. You direct negotiation. A step up from that is a controlled negotiation and a mediation. If mediation fails or it's not in your contract, then you're either going to litigation or arbitration, again, depending upon your contract. And there's your answer right at the bottom. Read your contract to figure out exactly what your options are for this dispute resolution process that you're going to be in. If you're going to file a lawsuit, if you're going to file for arbitration, be prepared for a counterclaim, because that's the best way to defend. It's always the way they do defend. And that defense is no change orders, back charges, all kinds of things. If you are prepared ahead of time, you should walk through easily. Like I said, most cases don't go to trial. Most cases don't even get to the dispute level like this. As I said, I've been doing notices. Well, notices of furnishing came about in Ohio in the early 90s. I've been doing them since then. And on average, I have found that 1 in 10 of the notices I do go to a mechanics lien. And surprisingly, 1 in 10 of mechanics liens go to a point where we are ready to file or actually file a lawsuit on it. So if you're doing a notice of furnishing, you're talking about 1 in 100 that is going to actually make it to a lawsuit. And I'm not saying you're going to go to trial, because now it's 2% of those that go to trial. So very small amount, but you're bleeding money when you're paying a lawyer to handle all these things. So if we start at the beginning, you file your lien. Actually, you generally have your lawyer file your lien. So you file a lien and be prepared for the discussion that comes afterward, whatever the defense is going to be. Work with your lawyer to resolve it, to try to get out of it with a good business sense. So what you're doing is weighing the balance. You know, you have to kind of do higher math to figure out, do we have a 50% chance of winning? Do we have a 75% chance of winning? If it's 50-50, you want to settle. If it's 75, you probably want to settle. If it's 120%, yeah, right. You know, maybe you want to think really seriously about threatening trial, pushing hard, because they may collapse, because you've done your documentation so well and they know they're going to lose. One of the interesting things about a mechanics lien is the Ohio statute permits us to collect legal fees for the plaintiff if we prevail. The downside is that you can only get your money, your legal fees, out of the pot of money that's realized at the foreclosure. So there may not be enough money to pay everything at a foreclosure, so you may not get 100% of your attorney's fees, and then a judge has to give you the attorney's fees, and judges don't like to do that frequently. So yeah, maybe it's going to be there, maybe it isn't. It sounds like a complicated process. It flows much easier than that. If you are very sophisticated about doing business negotiations, great. If you're not as sophisticated, particularly if you're dealing with a lawyer on the other side, don't do that. Be sure you have somebody else negotiating for you, whether it's your spouse, so you have that plausible deniability, or your lawyer, who is going to have real plausible deniability and can cut through the pile of misinformation that they're trying to give you. I had one experience right when the law changed in Ohio about doing notices of furnishing and all that stuff. I had a lawyer who I respected quite a bit, and he called me. I filed a lien, and he said, nice chat to start with. He said, I'm calling you about this lien, and you know, your lien is invalid because you didn't do it the right way. And as this notice of furnishing thing was coming into play, there were projects that had a contract that was signed, the project between the owner and the contractor, that contract was signed before the law went into effect, which meant there was no notice of furnishing, no notice of commencement. If it was signed after it went into effect, there was. And he said, I really hate to tell you that this is a problem. You didn't get this right. And I forget which side it was on. I think he said that we didn't do a notice of furnishing and we were supposed to because it was signed after. And I said, geez, I'm always been so careful on this. I always get a copy of the contract so I know when it was signed. Let me go back and look. And I went back and looked, and sure enough, I was right. So I called him back and I said, no, Andy, we did it right here. He said, oh, okay. Well, then you didn't properly serve it. He said, didn't, what? What do you mean I didn't serve it right? Let me go back and check, because I trusted this guy. And I went back and it was served perfectly. And he said, oh, well, you filed it late. I said, no, Andy, it's a properly done lien. It was papered properly. It was served timely. It was filed timely. Just tell your client to pay the money. And he said, okay. So he tried to bluff me. And the downside to that is I've never trusted him again. And that was in 1992. So it's only been 31 years that he has burned trust based on that. So you have to be careful about that. Anyway, Diana, are there any questions?
No, Russell, I do not see any questions at the moment.
Okay, well, here, for anybody who's watching, or if you're looking at this recording later on, if you have a question, feel free to give me a call. I'm always happy to talk about information that I have given in a webinar like this. If you happen to be a Builders Exchange member for Cleveland or any of their related Builders Exchanges, or you're a Home Builders Association member in the Greater Cleveland, you also get free telephone calls with me, 15-minute calls on general issues of law. So feel free to use that, and you won't get charged if it's just about this. If it's about anything else, use that free benefit. And I'm glad to talk to you, glad to help you with what you need to get you going in the right direction. So with that, I will hand it back to you, Diana.
Thank you. No, I was just going to ask you to go to the next slide so they can see our information. Thank you.
Okay, that's it. And if you have a look at that, you've got that information. You want me to go to the next slide, Diana?
Yes, please.
Okay, so finally we have our little opportunity here to give us a review. Please do that. If I can make this any better the next time, I'm happy to do that. I'm always open to suggestions. So that'll wrap it up. I'll give you time to open that up for a moment and then close on our final page here. Thanks, everyone, and thanks, Diana.
Thank you very much, Russell. Thank you for your time, everyone. Have a good day.